These types of the written orders can be habeas corpus, mandamus, prohibition, certiorari, quo warranto. Habeas corpus, Latin term, it means have and corpus means body. Sorry. It is issued to a person in his or its custody at a specified time to a specified place for specified purpose. It is a personal liberty to a person. Mandamus, we command to a public official to perform his or her duties. Issued against any public body, a corporation, inferior court, tribunal or government. Cannot be issued against a private individual or body. Departmental instructions not have statutory force. Duty is discretionary, not mandatory. To enforce a contractual obligation, President of India or state governs. Chief Justice of High Court acting in a judicial capacity. So in all these cases, the mandamus is issued in written form. Prohibition, to forbid or inactivity. Preventive issued to lower court, tribunals to prevent exceeding jurisdiction, usurping jurisdiction against judicial and quasi-judicial authorities. That means not available against administrative authorities, legislative body, private individual and bodies. Certiorari, to be certified, to be informed, or it means preventive and curative decisions. Issued to the lower court or tribunal to transfer the quash, the order on the grounds of excess or lack of jurisdiction or error of the law available against administrative authorities. Not available against legislative bodies, private or individual bodies. So all these cases are covered under the prohibition to forbid inactivity. Certiorari, a writ or a written form of a law or order is called a certiorari, is an order for removal of a suit or a case from an inferior or a lower level of court to a superior or a higher level of a court in interest of speedy or faster justice. Objective is basically to ensure speedy or faster justice and also prevent an inferior court not competent to deal with the case. Quo warranto, or by what authority or warrant. Issued to the enquire the legality of the claim of a person to public office. It prevents the legal usurpation of public office by a person. Issued only in a case of public office of a permanent character created by statute or constitution. Cannot be issued in cases of ministerial or private offices. Cannot be sought by any interested or not necessarily by aggrieved person. That means what? A kind of warrant is issued through authority only and it comply to the concerned person only. Public interest litigations. The P.N. Bhagwati also started this process of public interest litigations. This process in India supported by Sabyasachi Mukherjee. Any social action group can approach court in case of denial to poor from justice due to poverty or no money. Who can file a writ or petition under public litigations? Individuals. Social group, Article 226, that is breach of right under Article 32. Cases filed through lawyer. Criticism, judges overact for publicity rather than giving justice was the criticism for this. We can see example of public interest courts and the lawyers who doesn't charge any fees, but through the government authorities they are appointed for the candidates. We can see an example of Vishakha Datta case versus state of Rajasthan, wherein a rape case was happened, wherein the justice was given to the concerned labor, and the famous case which was fought by the social group called Vishakha Datta, it became one of the cases against Rajasthan court. Martial law or military rule (FRs) comes under Article 34, restriction on FR. Parliament can indemnify, secure someone against legal responsibility for their actions and protects acts done by any government servant. It cannot be challenged on court. Martial law not defined in Constitution. No specific express provision to declare martial law. In Article 34, it is implicit. Circumstances like war, invasion, insurrection, rebellion, not violent resistance to law, etc., etc. That means a kind of situation wherein the country is having problems of fight, terrorist attack or religious fights, etc. Supreme Court martial law does not ipso facto result in suspension of habeas corpus. Martial law different from the national emergency. So military rule will be implied when the state authorities are not able to cope up. The central government imposes military rule, affecting certain fundamental rights under Article 35. Parliament make laws to give effect to certain FR or Article 16, 32, 33 and 34. Parliament make laws to punish effect offences under FR, Article 17 and Article 23. This extends in some places to sphere of the state legislature. Present position to right to property. Right to property created series of amendments related to compensation for acquisition and requisition of private property. 1st, 4th, 7th, 25th, 39th, 40 and 42. So 44th Act abolished the right to property as FR or inserted as Article 300A in Part 12. Still, it is legal and constitutional right, not basic structure and no guaranteed right to compensation. Exceptions to fundamental rights. Savings of the laws under Article 31A or the first A Act. If a violation of Article 14 and Article 19, the 5 categories can it happen: acquisition of estates, taking over property management, amalgamation of corporations or mixing up of companies, extinguishment or modification of rights of director, shareholder or corporations, or extinguishing or modification of mining leases. Does not immunize a state law from judicial reviews if it receives precedent's assent. Fundamental duties. These are in the Article 51A of our Constitution, introduced by 42 Constitution Amendment Act of 1976. There are 10 fundamental duties which are stated in the Constitution for the Indian citizens. Every citizen must respect the Constitution, respect national struggle. Citizens must protect sovereignty, unity, integrity of India, defend country. Citizens must promote harmony, value, honor and preserve rich heritage of India, protect and improve natural environment, develop humanisms, safeguard public property, reach higher levels of achievement. A new clause K to Article 5186 Constitution Amendment Act compulsory education to child from 6 to 14 years is added. Fundamental duties. Article 51A says, added to Constitution by 42nd Amendment Act in 1976 upon the recommendations of the Swaran Singh Committee. The duties set in Part 4A of the Constitution of India, they are not legally enforceable. They are held by the Supreme Court to obligatory for all citizens. Originally 10 in number, the fundamental duties were increased to 11 in 86th Amendment Act in 2002. What are these duties? The exact duties of every citizen of India according to Constitution are to abide by the Constitution and respect its ideals and institution and the national flag and national anthem. Second is to cherish the and follow the noble ideals which inspired our national strength for freedom. Third is to uphold and protect the sovereignty, unity, and integrity of India, to defend the country and render the national service when called upon to do so, to promote the harmony and the spirit of the common brotherhood amongst all the people of India, transcending religious, linguistic, and regional or sectional diversities, to renounce the practices derogatory to the dignity of woman, to value and preserve the rich heritage of our composite culture, to protect and improve the natural environment including forest, lake, river, wildlife, and to have the compassion of living creatures, to develop the scientific temper and the humanisms and the spirit of inquiry and the reform, to safeguard public property and to abjure violence, to strive together excellence in all the spheres of the individuals and collective activity, so that the nation constantly rises to a higher levels of endeavor and achievement. Who is a parent or a guardian to provide opportunity for education to his child, as the case may be, the ward between the age of 6 to 14 years? Significance or importance of these fundamental duties. They serve as a reminder to perform specific duty towards society and warning to the citizens against any of the anti-social activities. They serve as a warning against the anti-national or anti-social activities like burning the national flag, destroying the public property, and so on. They also serve as a source of inspiration for the citizens, not only promote a class or a sense of descriptive and commitment among them. They create a feeling that the citizens are no mere spectators but active participants in the realization of the national goals. If the court finds that if the law that is in question seeks to give effect to a fundamental duty, it might be considered to be a law. Saving of the laws, gives an effect to the creative direct principles under Article 31 and 25 and A Act. To implement social directive principles, Article 39B and 39C, someone rightly said that it has also been covered as part and parcel in Article 14 to 19. What is the importance of Article 31B? 31B saves conflict of the laws with the fundamental rights by giving the validation based on fictional immunity that laws enacted under it and placed in the 9th schedule are immune to the challenge in court. Even if such law violated fundamental rights. That's all for today. We'll continue in the next class. Thank you.